The Court of Appeals is now in session.
Good morning and welcome to the Court of Appeals, and nice to see you again, Ms. Pierce and Mr. Peterson. We are here to hear arguments in the matter of, KY. There's so many initials these days this morning. Counsel, if you could please, for the record, enter your appearances.
Martha Pierce, attorney guardian ad litem for the minor children.
Alexander Marshall for the appellant mother.
And John Peterson, Assistant Attorney General for the state of Utah.
And just out of curiosity, Mr. Peterson and Ms. Pierce, are you going to split your time again?
Right.
Correct, Your Honor.
Perfect. Thank you for letting us know that. As I said, or as we've already seen this morning, I know you are all familiar with our virtual courtroom and the procedures that we will follow today. Just as a point of reminder, when you are not arguing, if you wouldn't mind please turning off your camera and muting your microphone. That will allow us to focus on the lawyer who is making the arguments. Does anybody have any questions before we begin, before we proceed? Does not look like that. So Ms. Marshall, whenever you're ready, please begin.
Thank you. To give meaning to the termination statute and the analytical framework set forth by the appellate courts for termination cases, this court must reverse this decision. The juvenile court here failed to consider on the record a feasible alternative to termination, guardianship with a relative. In doing so, the court also failed to apply the statutory presumption that wherever possible, family life must be strengthened and preserved. These are threshold legal errors that are entitled to no deference by this court. The response briefs.
But this was a kinship placement, correct?
Correct.
And so what do we make of the court's failure to address it as far as a permanent guardianship arrangement versus a termination and permanent placement with the kin?
The fact that it's a kinship placement makes that failure to consider on the record even more problematic. A kinship placement is the ideal situation for permanent custody and guardianship. It's the one that's most commonly employed. So the fact that it is a kinship placement and that both the state and the and Mother's Council and the GAL and even the court itself during trial addressed permanent custody and guardianship, but then just failed to put any analysis in the order is even more problematic because of that, because of the facts that we have here. The response briefs all but concede that there is no findings or analysis that go to permanent custody and guardianship specifically. Instead, the response briefs state that the court impliedly found that, yes, sorry.
Well, so then my next question is, can't we get there by inference?
No, and the reason is it has to be on the record. We can't impliedly find strict necessity. Considering other feasible options under BTB, under NRA-GD, under NRA-GAL, that is part of the strictly necessary analysis. It's as if the court didn't do half the analysis, or at least didn't tell us what it did for half the analysis. We can't allow a court to imply strict necessity. It has to be on the record, laid out, so that this court can effectively review the decision. Otherwise, this court has no ability to thoroughly and transparently examine how the juvenile court got to its decision. And that's what's not permissible here. That's why it's a legal error and not something that we're going to defer to the juvenile court to just take it at face value that it must have considered it and just decided it wasn't a good idea. And to give this court an example, the kinds of findings that we would look for that aren't present here to support why a permanent custody and guardianship is not feasible are findings that go to the co-parenting skills between mother and foster mother, or specific reasons why any contact, even in structured visits or in therapeutic visits, would not be beneficial to the children or would be actively detrimental to the children. None of those findings exist in this order. There are findings about why custody cannot be returned to mother, and most of those are based on one type of finding, which I'll get to in a little bit. But
she's not asking for a return of custody. She's only asking that her rights not be terminated.
At this point, that's what we're challenging. We're challenging the strict necessity of termination. So whether that means when we go, if this court were to remand and we go back to redo the best interest analysis with all of the present evidence is required by case law, then whether or not custody gets returned would depend on the circumstances that exist now. So it's not a
Well,
decision this court has to
even
make.
worse for her?
I'm sorry, can you repeat that?
Won't that even be worse for her?
A remand? You mean like the current evidence?
The circumstances that exist now. Doesn't that-
Possibly.
Doesn't that at least lead to this outcome?
To a permanent custody and guardianship outcome or to a termination outcome?
One or the other?
Possibly. It possibly leads to one or the other or neither. It depends. Mom could be doing much, much better. She could be much more stable. She could have continued therapy. She could have found ways to be more skilled in addressing children that have endured severe trauma, which is what we have here. These are highly skilled things, and she may have gained those skills in the meantime. Yes.
Piggybacking off of the discussion you've been having with Judge Appleby, as I look through the juvenile court's ruling, you're right. I don't see a place where it specifically says it's rejecting the permanent guardianship for these reasons. But I see a lot of reasons that the juvenile court is giving for the decision that it did make and that it did lay out. I mean, it has a finding on record 296 that she was having a hard time communicating with the children still. It's got a finding on 296 as well, that she has, quote, an inability to understand and comprehend her children's physical and emotional needs. It has another finding the next page about that she's failed to understand the trauma and so forth. And so why wouldn't we look at those findings and say, well, this is what the court is saying about why it's going the direction it's going, thus implicitly rejecting the permanent guardianship? Why isn't that the right answer here?
Because it's missing an inferential step. So those findings we could infer might go to why any contact with mother is a problem. But they don't necessarily, because we don't know whether or not that means that any visit is detrimental to the children. And when we look at the course of this case, that doesn't seem to be consistent with how the juvenile court handled the case. Mom continuously improved. The problem was she didn't improve enough, according to the juvenile court in the state. So it's not as if there suddenly became an issue with the contact with mother. The same issues existed throughout, and the court allowed visitation the entire time. In fact, mother had unsupervised visits for a significant portion of time. So it can't be fully and easily implied that any contact with mother is detrimental from the findings that were made here. We're missing that.
What about the incident in the park, though? Didn't that sort of underscore the court's determination that she really wasn't improving enough?
It did underscore that part of the findings. And that's an interesting situation because that happened almost a year before trial, that incident. And it also happened about, I believe it's 1 or 2 weeks before the second permanency hearing. So not the final one, but the second permanency hearing, where the court decided to extend reunification services. And at that point found by clear and convincing evidence that it was in the best interest of the children to continue reunification services with mother and eventually return to her custody. So it's difficult to say how that incident can really play into this decision when at the time of that incident, the court found by clear and convincing evidence that it was still in the best interest of children to continue to have at least contact with mother, if not be reunified with her. So it's a difficult thing to weigh that one incident with the evidence that came out at trial. The evidence at trial, and I'm getting a little bit more into my sufficiency argument here with regards to whether it was strictly necessary to terminate based on what seems to be multiple iterations of the same finding, which is that mother did not internalize the skills necessary to support her children emotionally. And at trial, we have evidence from her therapist, from herself, and from the children that all indicate that she is making progress in this area. Again, we're looking at an issue of degree, not an issue of whether she can or tried or wanted to. She absolutely did all those things. It's just whether she could do it enough. And I think here it's important to remember that we're dealing with children that have endured severe trauma and a child who has a disability. These are not easy things to learn to deal with. There's no doubt that this family would need continued therapy. And this kind of goes to whether or not there was another option that was feasible. Another option that's feasible is a guardianship. We don't terminate. and we continue therapy. We continue working on this. We give this family a chance to develop the skills that it needs in order to have safe contact together, in order for mother to emotionally support those children. Yes.
But with all of those extensions, isn't there a point at which, they've had enough time and we can see that this is a failed experiment? The other thing I wanted to ask you about, so there's that question, but there's mention, especially in the red brief, that she was in assisted living of some sort. So, isn't she getting support all along and it's still not working?
So there's a couple things for that. With the statutory timeline in child welfare cases, I agree that that's what tends to happen. What tends to happen is we get to the end of the 18 months and we say, well, we didn't get there, so we're done. Termination. But that's not the correct analysis. At least it's not anymore. Not since the statutory language changed and not since we developed the strictly necessary case law more. Now what's required is there another thing we can do? Is there some other way that we can keep this family together and still support the needs of the children? That's the question we need to be asking. And so if there is an option that allows that, the court at least needs to do that analysis, but it is required to take that option instead of termination. So in a sense, where mother got to was she was making progress. She was trying. There was a lot of setbacks. COVID affected this case. The fact there's this huge waiting list for peer parenting, which is one of the fastest ways for parents to gain those hands-on skills. All of those things set mom back in terms of time. And when we're against a clock, that's a really important factor. So at the time of termination, instead of saying, well, we didn't quite get there, it's a failed experiment, we just have to terminate, the question needs to be, and this is where we contend the error is, the question needs to be, is there another option? Can we put in place scaffolding going forward that will protect this family and allow them to have the skills going forward? And part of that, to the second part of your question, she was in not quite assisted living, but it's sort of, as best as I understand it, and I don't pretend to understand it well, it has some additional resources for her to draw on, like counseling, things like that. So she did have that structure in place. She also had employment. She was pretty stable in terms of where we ask parents to be at the end of these kinds of cases. And she did everything that was asked. She did all the therapy. She did all of the services that she could. So that's really the crux of this, is whether or not there was another way to keep this family together. And here we're saying there is another way to keep this family together. And at the very least, the juvenile court needed to explain why it couldn't do so. Thank you.
Thank you, Ms. Marichal.
Martha Pierce, attorney guardian ad litem for the minor child. I want to direct this court to the case of In Re KF, which is a 2009 case. It's 2009-4. That time, the mother raised a claim that the findings were not sufficiently detailed to provide for a meaningful appellate review. There were not enough steps in the findings. At that time, there was a case, a 2004 case, that said, if you have a problem with the findings, you have to preserve them. And this court, in the meantime, wasn't really comfortable applying. It's called 438 Main Street versus Easy Heat. This court wasn't really comfortable applying that case in child welfare cases. And so when KF came up to this court on its own motion certified it to the Supreme Court and asked the Supreme Court to revisit whether or not 435 Main Street applied to child welfare cases. So the Supreme Court took up that case. Chief Justice Durant wrote the opinion and said, yes, in child welfare cases, you have to preserve claims where you say the findings are inadequate to facilitate meaningful appellate review. And the reasoning is very meaningful for child welfare cases because it says what mother wants here is an easy fix. It's totally an easy fix if you do it at the trial level. You're not happy with the analysis, you ask for more detailed findings. And the Supreme Court said that's a fix that's easiest to apply when it's all fresh in the judge's mind. And instead, you want to go up on appeal and ask this court to remand it and ask the trial court to do what it could have done 2 years ago. And I would add that another really important reason why failing to do this is not only bad law, bad appellate practice, it's also really bad for the children. All of our process in child welfare cases are meant to reflect a child's sense of time and are meant to be developmentally appropriate. So if there is a fix that's easy that we can apply at the trial level, why don't we do that? Why do we get 2 years into a case and then remand it because we're not happy with the findings? So I would say that an appellant has a duty to preserve this claim. Otherwise, this court is entitled to rely on the presumption of regularity. Now, regarding Mother's other claims, her sufficiency of evidence claim, what's fascinating to me is if you look at her brief and listen to her oral argument, it really does sound like a closing argument at the trial level, where she presents her evidence in a light very sympathetic to her position. And this court could be forgiven if you have moments where you start thinking, wait a minute, am I trial judge? Instead of raising a claim of error. Even after this court, the Supreme Court abandoned the marshalling requirement as a fail-safe, it said you still have to, if you're raising a sufficiency claim, yes.
I didn't take her argument that way at all. What I understood her argument to be was fairly cogent, which is that she had Mother below had requested a permanent guardianship. That's in front of the court. That's part and parcel of the determination that the court has to make, and the court just simply didn't address it at all. I mean, I take your point about 438 Main Street. It's been a while since I've read that case or KF, but it seems to me, listening to your description of it right now, that it's one thing to say, well, the court said A and B, but it didn't quite get to C and D. But what I understand Mother to be saying here is the court just doesn't say anything about the permanent guardianship request, even though it was squarely in front of it, and it was squarely something it needed to decide on. And so why wouldn't we just send it back to the court and say, you didn't address this at all? Tell us why this is not appropriate. Why is that a closing argument-esque kind of argument as you're putting it now?
Well, I said it's a post-judgment issue, that you raise that issue post-judgment if the court did not address it. You can ask, that's what NRKF said, is you do it via a post-judgment motion. And when you said a permanent custody request, the request in this is on the
permanent guardianship. Sorry, I mangled the terms in my.
I was saying who made the request, and the request was made by Mother, not the foster placement. And in my brief, I cite to a Supreme Court case in adoption of BB, and that is dealing with ICWA. And that one is saying, look, if no one has petitioned to have permanent custody and guardianship, you don't have to consider it. Now, permanent guardianship has all kinds of advantages, all kinds of disadvantages, and Aunt never petitioned. That was never on the table. So I'm not sure that the juvenile court really has to consider that. Now, something else and this is in BTB.
Wait a minute, Ms. Pierce. Didn't Aunt said that she was open to either and that she preferred an adoption?
Well, she's not going to give up these kids. If it has to be permanent guardianship or nothing, she will go with that. But she never petitioned for that. That petition was not on the table. So she wouldn't go for that. But I do want to point out that in NRA BTB, that involved a direct file private petition. And the court in BTB, and I think it's paragraph 70 to 71, said you have to look at BTB in the context in which it arose. Because in BTB, you only have the termination trial to consider feasible alternatives. And when you have an underlying child welfare action, the permanency goal, feasible alternatives are issues that are raised and they're required to be raised by law at virtually every single hearing, beginning at the shelter hearing. So this is an ongoing discussion that the court goes through, and as the evidence changes, as new facts emerge, then new things are considered. But I think you really can't look at only what happens in the termination trial. You have to look at the events of the whole case, and that's why the juvenile court admitted all these records from the underlying child welfare case, because there's that ongoing discussion. What else BTB said is that the provisions of ASPA did not apply because the state wasn't a party in BTB. And when the provisions of ASPA apply, ASPA actually has competing rule-out provisions. So whereas BTB said you have to rule out a higher permanency option before you can go to, you have to rule out permanent custody and guardianship before you can go to adoption. ASPA requires the reverse. ASPA says before you can go to a lesser permanency option, you first have to rule out adoption, and it requires several steps for both the state and the juvenile court to go through to rule out that option. So I think given the length of the whole case, you can rule that out. And the girls provided the best evidence of why permanent custody and guardianship would not be an appropriate option. And mom, actually, she provided some of the best evidence when she said, I think I should be able to visit every single day. I mean, what a nightmare that would be for the aunt. The aunt and the girls definitely need more protection than that if that's the mother's attitude. So if there's no questions, and it looks like there aren't, then I'm going to thank you for your time. I'm going to ask you to please respect these girls' testimony and please respect INRAE KF and please affirm this termination order. It has gone on way too long and these girls have been traumatized. Thank you.
Thank you, Ms. Pierce. Mr. Peterson.
Let's see.
I will say it doesn't appear that we have a clock. Oh, maybe it's back.
Right, like I can make do, I suppose.
Okay.
May it please the court, John Peterson on behalf of the state of Utah. I guess I'll start off with where Ms. Pierce sort of ended, and I mean I agree just as a general rule. I mean that preservation is best practice for sure. I think to some extent this court and the Supreme Court's decisions in BTB have essentially have made the best interest and strict necessity analysis a mandatory part of every case. I mean, so I really do. I mean, and I've argued before this court before that there is an affirmative onus on the juvenile court to make those basic findings about grounds for termination and whether or not termination is in the best interest, which also includes a finding of strict necessity. And I mean, and there clearly, I think everybody can see there's a bit of a mission in this case. I mean, but I would say it's one of really crossing the T's and dotting the I's. If you read through the court's findings, Judge Appleby.
Yeah, so my question is just can we just do this by inference or implication based on other things the court said, or do we just have to focus on what's in the findings and conclusions?
And I would argue that you very much can, reach an affirmation based upon the findings as a whole. I mean, really, I mean, what is missing is essentially, one sentence. The court finds that, continued contact with mother would be actively detrimental to the child's well-being because, she's unable to read their emotional feelings and continues to damage them. Yes, Judge Tenney.
Yeah, but that feels like a very big sentence if that's what's missing. I mean, in response to some questioning about that in her opening argument, Ms. Marichal pointed out, I think with some force, that it would be one thing for a juvenile court to say, hey, the situation is so bad that I think it's terrible for the kids to have any contact with mom. It would be another thing for a juvenile court to say, I think the situation is so bad that I don't think that mom should be their guardian, but I think that something akin to a permanent guardianship with some sort of visitation component would be okay. I mean, there's a lot of wiggle room in between these sort of different options on the table. And what I understood Ms. Marichal's point to be is the juvenile court doesn't tell us ever that it thinks the situation is so bad that mom can't have any contact at all. That's something of a gap. So why is that gap not so big that we shouldn't just send it back to the juvenile court to make it say that if it's really intending to say that?
Yeah, I mean, I guess I mean the short answer is, I mean, it's the nature of the case. These cases are that they're child welfare cases. This is a case that arose in the spring of 2019, and it's easy for us as lawyers to say, let's just send this back and and fix it. But if that's necessary, it's necessary. But it's not necessary. I mean, every time something happens in this case, it's another trauma for the children. And they're like, oh, now things are up in the air again. What's going to happen? I mean, the clear testimony is that these kids are very, very worried about ever going back. And no one suggests really that mother's ever going to have custody of them. But that's something which really traumatizes them. Yes, Judge Appleby.
Isn't the passage of time inherent in every one of these cases? And so if that's a basis for never reversing because it's going to disrupt the placement, then why have an appeal at all?
I mean, that would be true of every case. I would say this case, I mean, more time has passed than many. I mean, by the time of so April of 2019, we had removal, and we had the permanency hearing. The state started seeking a termination of reunification services in October of 2020. You had an evidentiary hearing in November of 2020 where the court finally determined services, and then termination trial months after. I mean, it's been, even by child welfare standards, I mean, mother received 21 months of services. And so I think the court's findings have to be read in light of we've really done everything practically speaking, and even after over a year and several months of services, you have the July 2020 incident, which shows that really absolutely nothing has changed. Mother may have done some work on herself, but she has no idea how to interact with her children in a way which isn't damaging to them. I mean, this incident
So
was
that incident is really disturbing, but what about Ms. Marshall's argument that the division continued to try to work with her?
They continued, but that incident marked a very big turning point. I mean, visits became, supervised again at DCFS offices after that incident, and shortly after is when the state sought to terminate reunification services. I mean, and Mother asked for an evidentiary hearing, so there was some more delay. But that really was, in my way of thinking, I think everyone's thinking that was a turning point, because we were like, this is not working at all. And I mean, it's very clear that after extensive amount of time, this simply isn't working. And I mean, the children cannot be any more clear. And even, I mean, there was a testimony from the aunt at the evidentiary permanency hearing that after the July incident, SY was at supplemental record at 248, and she said that she didn't even want to have visits anymore. I mean, and I don't disagree that the court could have done a better job, but I think if you read its decision in context of all this happening and all the testimony presented, and the court's findings about Mother's simple inability to read the children's emotional cues, that it's not difficult to see what that extra sentence, would have been in the court's mind. And
But isn't it essentially the court saying enough is enough?
I believe that is being very accurate, Judge Appleby.
Okay, so but is that enough?
I mean, at some point, it does have to be enough. I mean, even that.
But
Yeah.
why though? Because even taking into account the July park incident, the 2020 park incident, that could lead to a permanent guardianship with Aunt, consistent with concern about the park incident. Because at that point, you'd be saying, well, Aunt's permanent guardian, so that's going to allow us to prevent this kind of thing without actually terminating Mother's rights. So even if the court's concerned about that incident, you could still get to permanent guardianship.
I mean, in theory, I mean, it does. There's a bundle. I mean, Mother does have, legally enforceable rights that still remain. I mean, so it's not just, completely at the aunt's discretion. I mean, you could also argue, I mean, that termination of parental rights doesn't necessarily foreclose contact. I mean, the aunt, they are a family, and they are going to remain family.
So, Mr. Peterson, along those lines, will you just edify me that I may have just missed this in the record, but who is the aunt related to besides these kids? Is this the sister of the father who adopted them, whose rights were terminated, or is this the sister of the mother?
My recollection now, yes, is its Mother's sister.
Okay, thank you.
I'm not 100, but I believe
But at least in theory, even with her rights terminated and the children adopted, they might have some sort of relationship with their mom.
Yeah, I mean, they clearly have. I mean, there's testimony from the aunt, and she experienced a lot of frustration with Mom because she just felt, that Mother would not listen to her suggestions about how to do much of anything, and she really was just the same old mother she's always been. I mean, so they do seem to have some degree of relationship, and I think notwithstanding lack of time, I believe I've used up my time. So if there's no further questions, I would submit it to the court on the briefs.
Thank you, Mr. Peterson. Apparently our clock is down. So I guess we could either say, I'll try to keep track of time or just have at it.
Okay, well, hopefully it won't take too much longer.
Okay.
I'll kind of address things in backwards order.
We're
Preservation.
getting a note saying 4 minutes.
Sorry, can I start you on a question? Can you start with a response to what Ms. Pierce said about the preservation issue?
Yes.
And if you want to make this particular challenge, you've got to have done it below.
Yes. So my first response to that is she did not make that argument in her brief at all. In Re KF is not cited. Neither is Main Street or Easy Street. I'm not sure which one it is. that argument is completely new to me. So coming up with an answer on the fly for that, it's, I think, a perverse requirement to require that something that is part and parcel of the analysis for strictly necessary, if the court doesn't do it, you then have to do a post-judgment motion to force the court to look at it, and only then can you appeal that decision. I don't think that's correct at all, and I don't think that's what KF would require. So I would just flatly reject that entire argument had it been made. Similarly, the argument under In Re, I think it was BB that the Guardian cited about the requirement that a foster parent has to petition for guardianship in order for that to be considered. That is not my understanding from any child welfare case. In fact, I'm not even sure foster parents have standing to petition for guardianship in that situation. It's possible it's a little bit different when we're dealing with a kinship placement, but I've never seen a child welfare case where that has been a requirement. And again, BB was not cited in the Guardian's brief, so I'm not entirely sure where that requirement is coming from or what that argument is. But I don't think that is a requirement. Also similar, the AFSA citing the AFSA, which is a federal statute, also does not appear in the Guardian's brief, is not cited, and it does not apply. It's federal law, but it is not federal law that overrides Utah termination statute or the case law of this court. So the hierarchy that lays out does not override what this court has said in BTB, which even though BTB was a private termination case and the state was not involved there, the logic and analysis from BTB was adopted by this court and the Supreme Court in multiple cases afterwards. In Re JAL, in Re GD, in Re ER, they all cite to the same language from BTB. So it's well accepted that framework applies across the board, not just to private termination cases. I hope that got all the way through the preservation question. Turning to what the state argued, the court has to earn its deference, I guess is the best way to put this. The juvenile court has to earn the deference that this court allows it. Otherwise, we're not doing appellate review. We're just saying, yeah, well, I guess the court did its job because it seems like you could get there. But as your honors have pointed out, there is a big gap to bridge here. There isn't any finding in this decision that conclusively would show that permanent custody and guardianship is not workable. It just isn't there. And in fact, some of the argument from the state supports a permanent custody and guardianship, right? This is mother's sister. They do have a relationship. Those are the reasons that a permanent custody and guardianship does work. It's not a reason to eliminate it. And relying on, well, we think that they'll have contact afterwards because they're family, that's not how strictly necessary works. And if we are going to give teeth to strict necessity, which we absolutely should, then we have to hold the court to making that analysis, to making those findings as to why mom cannot retain rights. And the rights she retains, just for the court's information, are the right to reasonable parent time, the right to determine the child's religion, and a few other like smattering of rights that are rarely used, things like consenting to marriage and things like that. So,
but at best, isn't this going to get your client a remand for further findings?
Most likely. Yeah, most likely that's what that's almost always the best we can get in these cases. Because of course this court does not want to step in the shoes of the juvenile court and make a decision for them. And that's essentially what the state's asking you to do here, is to step in the court's shoes and say, well, based on what we're looking at, based on the facts that we see here, we think permanent custody and guardianship was in fact rejected when it wasn't, and entirely possible from the findings that were present here. So in a way, we are asking this court to not do that, to not step in the shoes of the juvenile court, and to in fact hold the juvenile court to doing that analysis, so that not only in this case, but in future cases, that analysis is clear, so that this court can apply that meaningful, thorough, transparent review and apply the deference that is needed to the juvenile court without making inferences and bridging these big gaps with something that is so incredibly important, like the termination of parental rights. And I think that's all I have. Thank you.
Well done, just under the wire. Thank you, Ms. Marichelle and Mr. Peterson and Ms. Pierce, I'd ask you to return to the camera or return to court,
Yep.
if you wouldn't mind. We'll just say thank you all for your arguments today. Again, very helpful, and we appreciate you taking the time to help answer our questions and give us a better understanding of this case. We will take this matter under advisement and render a written decision as soon as possible to get you a decision and we can resolve this case. Thank you for appearing today, and we will be in recess.